Picture this. A man sits alone in a police interrogation room. No lawyer, no notebook recording his words. Just him, two detectives, and a confession that will send him to prison for 10 years. A confession he later claims he never wanted to give. His name was Ernesto Miranda, and what happened in that room in Phoenix, Arizona in 1963 would echo through courthouses across America for the next 60 years and beyond. This is the story of how police misconduct in America's interrogation rooms, on its streets, and in its courts didn't just destroy lives, it changed the law itself. When we talk about police misconduct, we're not talking about abstract constitutional violations. We're talking about real people, real families, real consequences, and we're talking about the moments when the system finally said, enough. Welcome back to the verdict room. I'm your host, and today we're examining the biggest police misconduct cases that forced America's legal system to evolve, sometimes kicking and screaming. Let's start with Ernesto Miranda. He was a 23-year-old with a prior criminal record when Phoenix police brought him in for questioning in March 1963. The charge, kidnapping and rape. Miranda spent 2 hours in that interrogation room. No Miranda warnings were read. He didn't know he could refuse to talk. He didn't know a lawyer would be provided to him if he couldn't afford one. And by the time he walked out of that room, he had signed a written confession. But here's the thing, Miranda didn't actually know what his constitutional rights were, and the police weren't obligated to tell him. That was legal in 1963. Arizona convicted him based primarily on that confession. He got 20 years. His case went to the Arizona Supreme Court, which upheld the conviction. But then something remarkable happened. The case reached the United States Supreme Court, and Chief Justice Earl Warren was watching. Warren understood something fundamental. A confession extracted from someone who doesn't know their rights isn't justice. It's coercion wrapped in a badge. In 1966, the Supreme Court handed down Miranda versus Arizona, one of the most consequential decisions in American criminal law. The ruling was stark and uncompromising. Before any custodial interrogation, police must inform suspects of 4 critical rights. You have the right to remain silent. Anything you say can be used against you in court. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. These aren't just words on a card. They represent a fundamental shift in power. They acknowledge that a person in police custody is inherently vulnerable, that the pressure of that room, that badge, that authority, it's enough to break someone's will, even if they've done nothing wrong. Miranda was released from prison. He was retried, convicted again, this time with other evidence, and served his time. But his name became synonymous with a constitutional protection that has shaped American justice for 6 decades. But here's what's important as we move forward through this story. Getting a legal right on the books and actually protecting people from police misconduct are 2 very different things. Miranda warnings became routine. Officers read them. Suspects acknowledged them. And yet confessions kept happening. Guilty pleas kept coming. The system adapted, and for many people, especially poor people, people of color, people without resources, those rights on paper didn't translate into protection in practice. Now fast forward to Los Angeles, March 3, 1991. A man named Rodney King, driving a white Hyundai, sees police lights in his mirror and makes a terrible decision. He doesn't pull over. He panics and runs. When he finally stops, 4 LAPD officers surround him. What happens next would be captured on video, a first in American criminal justice. A bystander named George Holliday was recording. For 81 seconds, officers beat Rodney King. Tasers, batons, fists. The video is brutal. It's visceral. It's undeniable. King suffered a fractured skull, broken bones, and permanent brain damage. Surely people thought this video would be enough. The officers, Lawrence Powell, Timothy Wind, Theodore Briseno, and Sergeant Stacy Kuhn, were charged with use of excessive force. But here's where the case takes a devastating turn. The trial was moved to Simi Valley, a community in Ventura County with a very different demographic than Los Angeles. The jury that was seated included no black members. The prosecution, led by Deputy District Attorney Terry White, presented the video evidence. It seemed straightforward. You can see it with your own eyes. But the defense team, and this is where legal strategy matters enormously, reframed the narrative. They showed the video frame by frame in slow motion. They argued that each blow was a separate, justified response to King's movements, that he was non-compliant, that he was dangerous. On April 29, 1992, the jury acquitted 3 of the officers completely. The jury deadlocked on Sergeant Coon. The acquittals shocked America. Across Los Angeles, across the country, people watched the video and saw guilt. They watched the jury verdict and saw injustice. The verdict sparked the 1992 Los Angeles riots. 53 people died. Over 1,000 were injured. More than 1,000 buildings were damaged or destroyed. Hundreds of millions of dollars in property damage. So what changed legally? The federal government prosecuted the officers under 18 U.S.A.C. Section 242, a Reconstruction-era statute that makes it a federal crime to deprive someone of their constitutional rights under color of law. Sergeant Coon and Officer Powell were convicted federally and served prison time. But the bigger change was systemic. The Rodney King verdict exposed the danger of jury bias, of inadequate jury pools, of how geography and jury composition could determine whether clear misconduct was prosecuted or ignored. It also highlighted something critical. Video evidence, even when it appears crystal clear, can be interpreted differently depending on who's doing the interpreting and who's sitting in the jury box. As we move into 2026, the lesson from Rodney King still reverberates. Body cameras have become standard in many departments, partly because of this case. The demand for accountability through video evidence became a clarion call for reform. But body cameras don't tell the whole story, as we learned painfully from the case of Sandra Bland. On July 10, 2015, Sandra Bland, a 28-year-old black woman driving through Texas, was pulled over by Texas State Trooper Brian Encinia for failing to signal a lane change. The encounter was captured on his dashcam. When Bland questioned why she was being pulled over for something so minor, tensions escalated. Encinia demanded she extinguish her cigarette. When she refused, he escalated further. He threatened to light you up, referring to his taser. Bland was removed from her vehicle, handcuffed, and arrested. 3 days later, she was found dead in her jail cell. The official cause was ruled a suicide by hanging. But the video of her traffic stop, the circumstances of her death, and questions about how a woman with no history of suicidal behavior ended up dead in custody. These sparked national outrage. Her family and advocates questioned whether she was actually suicidal or whether she had been harmed. The case exposed a critical gap. Body camera footage of the stop existed, but it didn't show what happened after Bland was taken into custody. There was no video in the jail. The body camera captured the misconduct, the aggressive traffic stop, the escalation, the arrest, but it couldn't prove what happened in that cell. Trooper Encinia was charged with perjury for his report about the stop, but ultimately pleaded no contest to a misdemeanor, receiving a fine. Sandra Bland's family settled a civil lawsuit for $1.9 million. The legal lesson was clear. Body cameras are only as useful as the footage they capture. They need to document the entire interaction, not just the initial encounter. And they need to be paired with robust accountability mechanisms. You can have video evidence of misconduct and still struggle to hold officers accountable if the system doesn't demand transparency and if the aftermath isn't recorded. As of 2026, body camera policy remains inconsistent across jurisdictions, and questions about when cameras must be activated, how long footage is retained, and who has access to it remain hotly contested. Now let's move to May 25, 2020, Minneapolis. A man named George Floyd called a store to buy cigarettes. The store clerk believed the $20 bill Floyd used was counterfeit. Police were called. Officer Derek Chauvin arrived. What followed was a 9-minute and 29-second encounter that was filmed by a teenager named Darnella Frazier. Her video, posted on social media, ignited a national movement. Chauvin knelt on George Floyd's neck while Floyd was handcuffed and prone on the ground, unable to resist. Floyd said, "I can't breathe," 27 times. He said "mama" repeatedly, calling for his mother. He lost consciousness. He died. Chauvin remained on his neck even after Floyd stopped moving, even after paramedics arrived. This time, the video didn't fail to convict. On April 20, 2021, After a 3-week trial, a jury found Derek Chauvin guilty of second-degree murder, third-degree murder, and second-degree manslaughter. He was sentenced to 22 years and 6 months in prison. The conviction was significant because it was rare. Convicting a police officer for an on-duty death is statistically uncommon. But the legal changes that followed are what matter most. Minnesota passed the George Floyd Justice in Policing Act, banning chokeholds and neck restraints, requiring de-escalation training, and establishing new standards for use of force. Other states followed suit. The federal government passed the George Floyd Justice in Policing Act in Congress, though it faced headwinds. The case forced a national conversation about qualified immunity. Qualified immunity is a legal doctrine that shields police officers and other government officials from civil liability unless they violated a clearly established constitutional right. In theory, it protects officers from frivolous lawsuits so they can do their jobs without constant fear of litigation. In practice, as many civil rights attorneys argue, it's become a nearly impenetrable shield that prevents accountability even in egregious cases. George Floyd's family sued the city of Minneapolis and won a $27 million settlement in March 2021, one of the largest settlement agreements in a police misconduct case. But Derek Chauvin's fellow officers, Thomas Lane, J.A. Kueng, and Tu Thao, all faced the reality of qualified immunity arguments. Courts initially dismissed some of their cases based on the doctrine. It took sustained legal pressure and appeals to overcome. As we sit here in June 2026, qualified immunity remains deeply controversial. The Supreme Court has declined to hear cases that would substantially modify the doctrine, frustrating civil rights advocates. Congress has considered legislation to restrict or eliminate it, but as of 2026, no comprehensive federal reform has passed. State-level reforms have been more successful. Illinois eliminated qualified immunity for police officers in certain contexts. New Mexico did the same, but nationwide it remains a major barrier to holding officers accountable in civil court. Here's what all these cases share. They expose patterns. Police misconduct isn't usually a one-off event. It's systemic, it's cultural. It reflects training deficiencies, insufficient accountability, and institutional resistance to change. Miranda v. Arizona gave suspects a right they didn't have. The Rodney King case showed us that video evidence, while powerful, can be manipulated and that jury composition matters enormously. Sandra Bland's case revealed gaps in accountability infrastructure, that surveillance has limits. And George Floyd's case proved that even when a case seems utterly clear, the system can still fail to protect victims. The reforms that followed each of these cases have been meaningful but incomplete. Miranda warnings are standard, yet false confessions still happen, sometimes by people who waived their rights, sometimes by innocent people convinced that cooperation is their best path. Body cameras are widespread, yet footage is still sometimes unavailable or inaccessible. Use of force policies have been reformed, yet officers are still sometimes acquitted or dismissed based on qualified immunity. So what's the path forward? As of 2026, we're seeing continued pressure for reform. The Innocence Project continues to exonerate wrongly convicted individuals, many based on police misconduct or suppressed evidence. The ACLU remains active in challenging qualified immunity and advocating for police accountability legislation. And at the state level, jurisdictions are experimenting with different approaches. Civilian oversight boards with real power, mandatory body camera footage, release policies, restrictions on qualified immunity, enhanced de-escalation training, and mental health crisis response teams as alternatives to armed police. The question isn't whether police misconduct cases will continue to shape the law. They will. They always have. The question is whether the legal system will move fast enough to prevent harm, or whether each case will continue to require tragedy, video evidence, years of litigation, and public outcry before change happens. That's the tension at the heart of this story. And it's a tension we're still living with today. Thank you for watching The Verdict Room. If you found this analysis of how landmark cases reshape police accountability compelling, please subscribe. Hit that notification bell so you don't miss our next deep dive into the cases that matter. And in the comments below, I want to hear from you. What misconduct case do you think most urgently needs legal reform in 2026? What's still broken in our system? Your verdict matters. Let's discuss it.